Good morning everyone, my name is Gijin Yi. Today I'm going to give a video presentation on fittings and fixtures. After going through the facts in Abraham case, it is important to distinguish between fittings and fixtures. Although there is a general maxim that is, whatever is attached to the soil becomes part of it, the items still have to be classified into two categories, which are fittings and fixtures. This is because any dealings with the land will take the fixtures, which they have proprietary consequences together with it, but not fittings. A fixture is an item that is affixed to the land and is integrated as a part of the land, while a fitting is an item that is not considered to be forming as part of the land itself. Here, the items involved are paintings and sculpture. In Holland and Hodgson, Blackburn Justice reaffirmed the general maxim of the law, but brought up a question of what constitutes an annexation sufficient for this purpose. The question of whether a fitting has become a fixture and a part of the land depends upon the intention of the original owner of the fitting as ascertained from the degree of annexation and the purpose of annexation. The first test, which is the degree of annexation test, focuses on the physical attachment to the land. Generally, the greater the degree of annexation, the more likely the object is a fixture. If physical damage will occur during the removal of the item, it might be a fixture. If the item is attached to the land in a permanent way and not temporarily, it might also be a fixture. And if an item is exceptionally heavy that is strongly held by gravity, then it might be a fixture. The second test, which is the purpose of annexation test, focuses on the reason why the property has to be affixed to the land of the property. It can be looked into two directions, that are whether annexation was intended to increase the value of the land and whether annexation was for the better enjoyment of the item annexed. In the present case of Abraham, four issues can be raised, which are whether the paintings are fittings of fixtures, whether the sculpture are fittings of fixture, whether the high value of the paintings and sculpture will increase the overall value of the property, and whether the intention of the parties will be taken into account in determining of an item on whether it is a fitting or a fixture. Regarding the first issue of whether the paintings in question are fittings or fixtures, the important fact here is that the paintings were hung on the walls of the property and could be easily removed. Applying the degree of annexation test from the case of Holland, there will be no physical damage occur during the removal of the paintings, as the paintings could be easily removed. They are attached to the wall in a temporary manner and they are not exceptionally heavy. In the decision of Hallowell and Eastwood, Parby delivered his judgment that the items would be considered as fittings when they were attached slightly so as to be capable of removal without the least injury to the fabric of the buildings, or to merely render the machine steadier and more capable of convenient use as fittings. When the item is question is no further attached to the land than by its own weight, is generally to be considered a mere fittings. However, even in such case, it is emphasized in the case of D'Encausse and Gregory. If the intention is apparent to make the items part of the land, they do become part of the land, and if it is to make an improvement to the property itself, the fitting will become a fixture. In this scenario, the advertising of the sale of a Victorian-style property shows the intention to make the Victorian-era painting an attraction of the property and thus make an improvement to the property itself. Other than that, in light of the case of D'Encausse, where evidence is produced that objects have been positioned so as to improve the overall architectural design of a property, those objects may become fixtures, even where there is no degree of annexation. Additionally, in the case of TSB and Bottom, if the object is part of the overall design of the building, the object will be a fixture. Applying the purpose of annexation test from the case of Holland, the paintings are fixtures as they form an integral part of the decoration or architectural design of the property and intended to increase the value of the land. Besides, in light of the case of Berkeley and Paulette, the paintings were not annexed for the convenience of the usage of the item itself, and thus they are fixtured. In conclusion, the paintings are likely to be fixtures as their intention to make them part of the land, which is to make the property a Victorian-style property for a better price and to become a main attraction to the potential buyers. As the onus of showing that they were so intended lies on those who assert that they have ceased to be fittings, Abraham needs to prove that there is intention to make the paintings part of the property. Regarding to the second issue of whether the sculpture are fixtures or fittings, the important fact here is that the sculpture were made from marbles and extremely heavy, but were strategically placed around the property to increase the overall aesthetics. Applying the degree of annexation test from the case of Holland, physical damage may occur during the removal of the sculpture, and they might be attached to the land in a permanent way, as the sculpture were made from marbles and extremely heavy. The sculptures are fixtures. In addition, when applying the purpose of annexation test from the case of Holland, the sculptures are fixtures, as they form an integral part of the decoration or architectural design of the property that the annexation was intended to increase the value of the land, as we can see from the fact that the sculpture was strategically placed around the property to increase the overall aesthetics. Besides, when applying the case of Berkeley in the current situation, the sculptures are fixtures, and as they were not annexed for the convenience of the usage of themselves. According to the case of Dee and Court, if the intention is apparent to make the items part of the land, they do become part of the land. And if it is to make an improvement to the property itself, the fitting will become a fixture. As there is an advertisement made for the sale of the Victorian-style property that attract Abraham, the sculpture will be fixtures as their intention. Even if sculptures have no degree of annexation, they will become fixtures as they improve the overall architectural design of the property. In summary, the sculptures are likely to be fixtures as there is a high degree of annexation because they are exceptionally heavy, and the annexations show the same intention with the paintings, which is to make them part of the land, which is to make the property a Victorian-style property for a better price and to become the main attraction to the potential buyer. The third issue is whether the high value of the paintings and sculpture will increase the overall value of the property. An item is affixed by the owner of the fee, though only affixed by bolts and screws, it is to be considered as part of the land. At all events, where the object of setting up the items is to enhance the value of the premises to which it is annexed for the purpose to which those premises are applied. This principle is conveyed in the case of Wilshire and Cottrell. Therefore, applied to the present case, both paintings and sculpture are fixtures because of the fact that the value of these paintings and sculpture were high, and they increase the value of the property by making the property a Victorian-era style. Lastly, the fourth issue is related to the intention of the parties. The subjective intention of the parties regarding to the question of whether the fittings has in law become part of the land is irrelevant. The Court of Appeal in Hobson and Gorin and the decision of the House in Mellish and BMI No. 3 Limited give an idea that the intention of the party is only relevant to the extent that it can be derived from the degree of annexation and the purpose of annexation. The label that the parties give to the object is not conclusive of its status. Therefore, Brenda's intention, which is subjective, will not be taken into account in this situation. All in all, both the paintings and sculpture are fixtures. As governed by Section 62 of the Law Property Act 1925, fixtures are deemed to convey with the land, and the purchaser is entitled to receive anything that is a fixture at exchange of contracts subject to any contrary agreement. Abraham can claim for damages under the common law remedies which are available as of right once the wrong has been proven. If the court finds an inadequacy of the common law remedy of damages, the court may award equitable remedy at its discretion, which are specific performance and injunction that probably require Brenda to return the paintings and sculpture to the property. That's all for my presentation. These are the references that I have been made. Thank you.